Good afternoon, everyone. Thank you for joining us for What's Next for Religious School Choice. My name is Andy Smerrick, and I am a senior fellow here at the Manhattan Institute. The primary reason for our getting together today is the U.S. Supreme Court's recent decision in Carson v. Makin. This was a 6-3 majority opinion written by the Chief Justice, and it explained that Maine could no longer exclude faith-based schools from the state's tuitioning program. The decision built on several cases over the last few years, and the court's position today, and forgive me, I'm saying this at the risk of oversimplifying things a bit, the court's position today on these issues amounts to something along the lines of, if a government entity is going to provide some kind of good or service, some benefit, like a grant, to a wide array of individuals and or groups, that government entity cannot exclude individuals or groups simply because they are religious. The government can't prohibit their participation because of their faith-based religious nature. Now, to some, the court's position now might sound completely sensible, maybe even intuitive. You could imagine someone saying, well, of course the government shouldn't discriminate based on faith. That's what the free exercise protection we have, that's what it's all about, right? But importantly, we should remember that this line of decisions that we're talking about now would have been pretty shocking a generation ago, and maybe even inconceivable 50 years ago. So from a historical point of view, what we're seeing today with Carson and some other decisions is notable, if nothing else. But looking forward, even more importantly, Carson and these cases that are that led up to it and are related to it are going to have major implications. So, for example, what does this mean for charter schools? Can they now be religious? What does this mean for faith-based providers of teacher professional development or foster care services or addiction recovery programs or historical trust programs? Can all of these types of programs access public funds to engage in explicitly faith-based work, or can those funds at least support buildings, activities, staff members who are working on things related to faith? And maybe most interesting to people who follow the news, how does all of this interact, if at all, with the other major religious liberty decision that was just handed down at the end of this term, Kennedy versus the Bremerton School District? This is the case of the football coach who was praying at midfield after football games. So obviously we have lots and lots to discuss, and we are fortunate to have two outstanding panelists to help us sort all of this out, both of whom I should mention here at the beginning filed amicus briefs with the court in Carson v. Makin. So first up is Nicole Stoke Arnett. She is the John P. Murphy Foundation Professor of Law at the University of Notre Dame, and I am fortunate to have her as a colleague here as a senior fellow at the Manhattan Institute. And we also have Michael A. Helfand. He is the Brendan Mann Foundation Chair in Law and Religion at Pepperdine University's Caruso School of Law. So before getting started, I just want to tell all of our viewers, listeners right now, if you have questions or comments along the way, just use the comments box off to the side. Type in whatever is on your mind, especially if it's a question, and I will try to get those into the bloodstream as quickly as possible. We want this to be a conversation with all of you. Okay, so I will hush up now, and I want to turn it over to Nicole with a pretty open-ended question, which is, would you mind getting us prepared for thinking about the Carson decision? For a generation or maybe even longer, the court had a jurisprudence that was actually pretty hostile to, or at least was proud of building a strict wall between state and state funding and faith-based institutions. So could you get us there, maybe up to, I don't know, the late 90s or 2000 before this series of Zelman and other cases came about? Where were we, say, 30 years ago?
Well, okay, so 30 years ago, the court, I would say, was beginning to kind of soften its approach toward church-state separation and allow more benefits to flow to religious institutions. I think if you back up to 50 years ago, so the case of Lemon versus Kurtzman, which adopts the famous Lemon test, the court has now abandoned, made clear in the Kennedy case this term. The Lemon test, Lemon actually involved subsidies for teachers in private schools, including faith-based schools, to teach in secular subjects. And the court says that's unconstitutional because it's a violation of the Establishment Clause. And then there's a whole bunch of cases that follow on Lemon about benefits to kids in religious schools and to religious schools directly. And they're literally, they tend to be quite hostile the Establishment Clause is seen as a sort of almost requiring the exclusion of religious schools from these public benefit programs. Sometimes they'll let stuff slide. It's kind of hard to predict what's going to happen. So there's a case that says you can give secular textbooks to religious schools, but not maps. This led Daniel Patrick Moynihan to famously quip, "What about atlases?" But so you could give, you could allow kids to have public transportation to get to school, but not to go to field trips. So there's a whole bunch of cases that they tend to be sort of very separationist. So most benefits may not come to anybody in a faith-based school, public benefits, even if it flows through the child. Beginning in the 1980s, I think in a case called Widmore versus Vincent, which I believe is 1981, the court says it's okay to allow who was a blind student to use a scholarship, a college scholarship, to go to ministerial school, to go get a degree in theology, that because the program that was neutral toward religion, it was available to all students, and this kid just happened to want to go to this religious school and get a theological degree. And I think that's an important turning point. And starting with that case, in a series of cases, the court starts saying, well, what the Establishment Clause requires is neutrality toward religion. So as long as the program benefits secular and religious beneficiaries alike, the Establishment Clause is not violated. What the Establishment Clause means is you may not disfavor or you may not favor religion over other things. And then it starts saying, I think importantly for Carson, or disfavor. So what the First Amendment means is the government must behave neutrally toward religion. So there's 10 years between Widmore versus Vincent, which is the scholarship case, and the very, very important case called Zelman versus Simmons-Harris, which is the voucher case. So that Cleveland passes a modest voucher program serving poor kids in inner city Cleveland. Kids can go to religious schools. 96% of the recipients are going to religious schools. This goes up to the Supreme Court. Supreme Court upholds the program, says no Establishment Clause violation. And there's no Establishment Clause violation because the program is neutral toward religion. The kids can go wherever they want. Just 96% of the kids happen to go to religious schools. The court also says, importantly, this neutrality means legal neutrality. It doesn't mean counting how many kids are in what schools. As long as the law in its face is neutral toward religion, the Establishment Clause is not an impediment to allowing the religious kids in religious schools from benefiting from public benefits, as long as it's open to everyone. So that's really, really important. Now, that's 20 years ago. And then they're sort of taken 20 years to answer some unanswered questions left over from Zelman. And the most important, I think, left over in Zelman is, well, what if a state doesn't want to include religious schools? Even if it can, does it have to? What if a state constitution requires the exclusion of religious schools? And so those questions take a long time to get between 2002 and 2022. For example, the Maine program at issue in Carson had been challenged, I think, 8 times. Including by me in 1997. I think I was among the first legal team to challenge the exclusion of religious schools from the Maine tuitioning program. And we lost on Establishment Clause grounds. Before Zelman, the Maine Supreme Court said, well, it'd be unconstitutional to let the kids go to religious schools. So what we have from Zelman until today is the development of this idea that neutrality isn't just a defense against an Establishment Clause challenge, but it's also a free exercise principle. That means neutrality can also be used as a sword to challenge programs that are not neutral toward religion and that disfavor religion.
So that is fantastic. And Michael, before I get to you with Carson v. Makin, I want to set you up a little bit more. So Nicole, would you just do the last couple beats on Espinoza and Trinity Lutheran? I guess both of these, one was from last year and maybe the other was 2018, but essentially some states, the question was called and the Supreme Court answered it. Is it okay for the state to deny participation to a religious group from a program that has wide applicability? And the court answered the same way in both cases. Do you want to just say a word about those cases?
I mean, very briefly, I think those cases are really important for a couple reasons. One is it said it's not okay to exclude religious providers because they're religious. But the other thing that's really important in the school choice movement is in both of those cases, the state said it had to exclude religious providers because of its Blaine Amendment, because of its state constitution. So in Trinity Lutheran, there was a program that provided recycled tires to preschools. Trinity Lutheran preschool was denied participation in the program because it was Lutheran. The state of Missouri said, we wish we could give you the tires. You seem like a really great preschool, but our Constitution, Missouri Constitution, won't allow us to do that. Supreme Court says that's a violation of the free exercise clause. It's religious discrimination. The state constitution itself is not sufficient justification to, allow the religious discrimination to go forward. And then in 2020, in the Espinoza case, the Montana had a very modest school choice program. The Montana Supreme Court invalidated it. And the reason it invalidated it, it said, we have this plain amendment and it won't allow us to give money to religious schools. There are religious schools in this program. We got to wipe the whole thing out. Supreme Court reiterates the Trinity Lutheran holding, saying, no, that's religious discrimination. You can't invalidate a program because it includes religious schools. And your state constitution or your desire to be more separate than the Establishment Clause requires is not a constitutionally sufficient justification for religious discrimination. So that's where we were in 2020.
That's fantastic. Okay, so now we're up to Maine's program. So Maine has had a program, I think, for a century or even longer, where because Maine is such a rural state, a number of its school districts don't even have secondary schools. They don't have high schools, so they generally have ascendancy relationship with another district, where a kid in a elementary school in one district who doesn't have a high school in that district can go somewhere else. The state had created a program where they would just give money to some of these students so they could go to a private school, even go to a school in a different country, pay for tuition at some other public school. But in the 80s, the state decided, yeah, you can do all that, but you can't use that money at a religious school. So, Michael, doesn't that just run right into Trinity Lutheran and Espinoza? Why was this even a case?
So I think the puzzle begins really in the beginning of this century, as Nicole just kind of laid out. One of the way to think about this area of law is, for all these years, there was kind of what I would describe as a no aid rule. By and large, government can't fund religion or religious institutions. And, really with Zelman v. Simmons-Harris in 2002, the waters start to kind of recede, where the state now says, no, you can fund religion so long as it's neutral. And maybe we'll talk about the second criteria later. And as long as it's neutral, this money is being given out to everybody. And in addition, the money is flowing to religious institutions, not directly from government, but based on the independent choices of families, of students to pick a school. And then the government is merely sending money based on the independent choice of individual students. So once the Supreme Court says that, it's like waters receding, and then you begin to see what the terrain looks like, as the waters have receded. And there's this huge mountain there, and it's wondering the following, again, as Nicole said, okay, so we can give this money on neutral terms to religious institutions, but what if we don't want to? In 2004, the Supreme Court gets a case called Locke v. Davey, a scholarship program for higher education available to citizens of Washington State. But it had an exclusion. You could get a scholarship, but you couldn't use it for a degree in devotional theology. And the question is, well, Washington State says, listen, this is our rule. We're not giving it to religion. We're going to give it out neutral terms, but not if you're going to pursue a degree in devotional theology. And everybody agrees in that case that the state of Washington could allow the scholarship dollars to go to religious, a degree in devotional theology. The state of Washington is just choosing not to. Federal Constitution says that's okay. State of Washington says, no, we don't want to do it. Is that constitutional? And in 2004, the Supreme Court says, yes, the state of Washington can have more stringent rules on the establishment of religion than the federal Constitution. And as a result, it can have this rule, no money, no scholarship will go for a degree in devotional theology. The question is why? And this has been the real puzzle of all these recent cases, Trinity Lutheran, Espinoza, now Carson v. Makin. Why was it in that case the state was allowed to exclude religion? Isn't that discrimination? And Justice Rehnquist, writing from the majority in that case, in his view, it's hard exactly to parse out what the argument is, but one view of the argument is, well, that was money going to train people going into the ministry. And that, based on our history and tradition, that is something that's always been a deep Establishment Clause concern. So even if the Establishment Clause allows it, because of the history and tradition here, the state should be also allowed to be more stringent when it comes to this kind of establishment clause concern. That's what we get in Locke v. Davey. As these more recent cases start to roll through, Trinity Lutheran, Espinoza, again, Trinity Lutheran, this case of you have this environmental grant program. If you're a nonprofit and you need to use tires, the state of Missouri was going to provide you funding in order to use recycled tires. Wonderful. Absolutely fantastic. But they said we can't give it to a religious institution. So there's the Trinity Lutheran School. Trinity Lutheran School loses the funding because they're going to their religious institution. And when this goes up to the Supreme Court finds in favor of Trinity Lutheran. They say, no, you can't discriminate. You can't exclude giving funding for a religious to a religious institution. That's prohibited religious discrimination. But then everybody wants to know, well, what about Locke v. Davey? You said back in 2004 that it was okay to exclude. And in Trinity Lutheran, you're saying that it's not okay to exclude. How do we differentiate those two cases? In 2017, Chief Justice Roberts, his view is, here's the problem. The problem is in Locke v. Davey, there was discrimination on the basis of how the money was being used. It was going to be used for a degree in devotional theology. In Trinity Lutheran, the exclusion by the state of Missouri was based on the status of the institution. It didn't matter what they were using it for. This happened to be recycled tires for a playground. There's nothing deeply theological about the playground. So that was just an exclusion based on who the institution is, as opposed to how the money was going to be used. This became known as the status-use distinction. You can exclude religion, at least so the thinking went in 2017. States can choose on their own, they don't have to, but they can choose on their own to exclude from government funding programs instances where the institution will use the money for religion. But they can't choose to exclude institutions because they are religious institutions. This has been a problem ever since, because you can describe status and use as status. I can do this kind of all day. There's a lot of talk in oral arguments about yarmulkes for some reason. Like, am I using money to wear a yarmulke, or am I a yarmulke wearer? Like, how can I describe in each of these instances, like, status can be use and use can be status all the time? And there is this great fear that this was a largely incoherent distinction. And so Carson v. Makin comes along, and here you have this case again, Andy, as you just mentioned, trying to provide funding for schools and school districts that don't have a public high school, but you couldn't send that funding to a religious school, a sectarian school. And the First Circuit, before this gets to the Supreme Court, says we can solve this problem. This is easy. We know how to deal with this case. Here's how we deal with Carson v. Makin. You're allowed to discriminate on the basis of religious use. And the problem was, here's what Maine was doing. They were saying no money to these schools because they were going to use the money for religious instruction. And as a result, no problem. This is a use issue. And as a result, we are allowed to exclude religion from government funding. Status, if we had said it's just because you're a religious school, that would have been prohibited. But this is different. This is what comes up to the Supreme Court. And ultimately, the Supreme Court is really being asked to opine on this distinction. Can we really live in a universe where we say religious use, that you can discriminate against, religious status, that's prohibited? And I'd say the primary holding of Carson v. Makin is this distinction doesn't matter anymore. It can't be that you can discriminate in one and not in the other, as I like to say. The core holding of Carson v. Makin is discrimination is discrimination. Doesn't matter if it's use, doesn't matter if it's status. These distinctions are complicated, probably incoherent, probably not based on anything. Ultimately, if you're excluding religion, that violates the First Amendment. And as a result, case Carson v. Makin, all these kinds of government funding programs, government doesn't have this kind of escape hatch anymore to say, no, we're not excluding religion because of who the institution is, but because of how they're using the money. That's no longer available as a legal argument. If you're excluding religion, you have violated the First Amendment.
That is outstanding. Thanks so much for that. 3 quick points. Number one, just a reminder to the people watching this. If you have any questions, comments, we're already getting a couple in. Please send them using the chat feature. I will ask our great panelists those questions once they come in. The second thing is we're going to spend more of the second half talking about this huge question. If there is no status use distinction anymore, what does that open the door to, or what does it require states to open the door to? But before we get there, I want to dive into one specific argument that Maine made trying to defend their case. Because when I talked to some even right-leaning lawyers prior to the case, some of them were sympathetic to one of Maine's arguments, which went something like this. Forgive me if I butchered a little bit for the sake of simplicity. Maine was trying to say to the court, listen, in your other cases like Trinity and Espinoza and Zelman, you were dealing with religious schools that were clearly private, and it was about taking kids out of the public system and they're going to a private school. What we have here with our tuitioning program is different. A lot of our districts, more than half of them, don't have a secondary school. They don't have a high school. So what we're doing is allowing some number of private schools to essentially function in our public school system. They're serving in the role of a public school, even though they're private. And we as a state, we're allowed to maintain a secular public school system. So shouldn't we as a state, in this tuitioning program, allow or limit the number of schools that participate functioning as public schools to private schools that have this essential feature of a public school, which is being secular? So essentially they're saying we're going to allow private schools to participate as public schools so long as they have this secular feature to them. Some people I talked to said, yeah, that seems completely reasonable. How did the court answer that question?
Well, I think, first of all, it's important to point out the court makes clear that Maine can set up whatever funding system for public education it wants to. It can structure its public education system however it wants to. Just the one thing it can't do is set up a private school choice program and then exclude religious schools. So I think, the problem with Maine's argument here is that they weren't actually providing public education. They were funding kids to go to private schools. So that's the first problem. So Maine, I don't fault Maine. Maine has a problem. I'm from Kansas. There are other ways to solve the problem. Kansas is bigger and more rural than Maine. You could have consolidation. You could have send receive arrangements. You can contract with another district. I mean, so there's lots of ways. I mean, you can do whatever you want. The one thing you can't do is set up a private school choice program and then say, but you can't go to religious schools. And I think rhetorically, if you listen to the oral argument, this argument fell completely flat because when pressed, so Justice Alito says at one point to the lawyer for Maine, so you're telling me that sending a kid to Andover, Exeter, or Choate is the equivalent of a Maine public education program, at public education? And the lawyer says yes. And he says, why? He said, well, because it's secular. So the only core attribute that the state argues about a Maine public education is it's secular. And some of the schools that these kids were attending charged tuition $65,000 a year before room and board. They were going to French boarding schools. They were going to elite prep schools. And so it just didn't, the argument sort of fell flat, I think, rhetorically. Legally, though, I think what the court is saying is, look, you can set up whatever program you want. You can abolish tuitioning. We're not telling you can. You have to do it this way. We're just saying if you choose to fund private instruction, you can't just say, except if it's religious.
Yeah. There's a great line, I think it's in Espinoza from the Chief Justice, you guys will correct me if I'm wrong on this, where he says something very straightforward like, listen, we're not telling you have to create a private school choice program, but once you create a private school choice program, it has to be open to all of them. You can't single out faith-based groups for exclusion on that, which I think holds in this. Can we just briefly, maybe for just a couple minutes, to show respect to the dissenters? There were three in this case, the three more left-leaning justices, and really there were two issues that they raised, disagreeing, not just in this case, but I guess with this set of cases that has come down. One is that I think Justice Breyer in particular was concerned about religious strife, that he didn't necessarily read call it textually what the exact words of the two religious clauses were, but he just thought that the First Amendment related to religion was designed to stop religious strife, and his concern was if we start funding these religious schools, there's going to be more religious strife, and that's not what our framers wanted. So let's go there. Do either of you have thoughts on this religious strife, and like that is part of our history and tradition? The First Amendment was designed in this way to stop religious strife.
Yeah, maybe I'll say a couple of things. First of all, there's nobody who's on team like pro-religious strife. I don't think. That's not, I think nobody likes religious strife. We've seen history's bad on this. Very terrible things happen. part of me wants to wonder if it, like, is this a data-driven argument? Like, do we see more religious strife when this happens? That's one way to think about what's going on over here. And I'd be curious to see what, not sure Justice Breyer's kind of, I wouldn't say his middle name is data-driven. And, it's like, it's not clear to me it's true. So I'm sympathetic to the idea. I guess the real question is it true in reality that it creates more strife? And I think I'm probably deeply skeptical of that idea. I'd like to think that a universe in which we live, where neutrality is our calling card, and we treat all things that advance a secular government interest in the same way are treated similarly. I'd like to think that that's the kind of principle that can stand the test of time and ensure that we don't have that kind of religious strife. Maybe one might say about Justice Breyer, maybe he'll be proven right in some way. I guess we'll see what happens, but it's not clear to me that there's enough evidence on the books to make us worry about this. And in fact, there's good reason to think that the principle of neutrality, even on Justice Breyer's own terms, might serve better on this front. And then just separately, it's not obvious that this is the kind of thing that the religion clauses are supposed to be thinking about. There's maybe just neutrality is what the principle is, even whether or not it kind of is in service of quelling religious strife.
So I would say on the point about it, whether it's an empirical question, I mean, certainly I think it's an ahistorical argument. The Establishment Clause wasn't about religious strife. It was about not having an established national church, or maybe not favoring one religion over another. But I mean, look, there was never ever any evidence there was religious strife in Maine before they stopped tuitioning kids to religious schools in 1980. 31 states, DC, Puerto Rico, all have private school choice programs. Only 2 of them have excluded religious schools, Maine and Vermont. So far as I know, Florida isn't like overwhelmed with religious strife because of its large tuition tax credit program. So my home state of Indiana, we seem to be getting along fine with vouchers. So I don't think there's any evidence that, allowing kids to choose to go to religious schools leads to religious strife. And I mean, on the point of neutrality, I mean, if I'm a religious believer, why would discrimination not itself cause religious strife? If you're saying to religious believers, we just don't trust you to make good decisions for your children, we don't trust your churches, and that seems to me there's at least as much of a plausible, logical argument that would cause division instead of the opposite.
Thank you. The other argument is a much more practical one that they made, which some people just know as the play in the joints argument, which is the dissent saying, listen, the free exercise clause says one thing. The principle of not establishing a religion says something different. There's some gray area in between, or they butt up against each other. They're kind of different things. You can't see them together. We just need to give our Republican governments, small r Republican, our Democratic decision makers, the ability to kind of sort this out in their own local context. And in Maine's context, Maine was saying, listen, allow us to do it this way. This fits with our view on what non-establishment means. So I think whether it's Breyer or Kagan, the view is just allow the Democratic branches some space in between these two religious provisions, the play in the joints, to make these kind of minor distinctions between who can participate and not. So do either of you have thoughts on this play in the joints kind of pragmatic argument? We should allow states to do stuff like this because it's not that big of a deal.
I guess we don't make exceptions for other kinds of discrimination. I mean, that's my argument. I mean, it's a little flip, but we don't say, oh, we're going to give, racial discrimination to the people. I mean, it's if you have a right, why, if you have a free exercise right not to be discriminated against by the government, why would that be different than other kinds of discrimination? It's sort of saying, well, religious discrimination isn't that big of a deal. And I just don't agree with that. So Michael probably has a more sophisticated answer.
I doubt that's ever true. Yeah. So, just following up on what Nicole just said, sometimes when I talk about this with friends or members of my, just my faith community, I often say that even if no dollars were at stake, these cases matter. Because ultimately the idea that government would roll out programs and then expressly exclude religion in circumstances, I want to make this crystal clear, circumstances where religion and religious institutions we're promoting and supporting the secular government objective in the same way. They qualify the program for the program, just like any other institution. And they were singled out and said no because it was either religious use or their religious status, I think strikes at the heart of the equal citizenship of religious members of, the United States. And so even if no dollars were at stake, that's why discrimination is so nefarious. It's nefarious because it's not just about the material benefits. It's ultimately about the standing of each and every individual American citizen, their ability to have access, just like any other citizen, to what we all get. So I just, the playing the joints has never been particularly persuasive to me for that reason. I want to go back also to one thing you mentioned before, Andy. The attempt to move up a level of generality, and when you move up that level of generality, you say no, that's the government interest is to do something secular. I just think in some ways that's even worse. It's for the government to say the government interest is to exclude religion. If we're taking kind of the non-material impact of this sort of discrimination as the core constitutional violation, that's even more harmful. Like that the government has its own independent interest in excluding religion, to elevate it as opposed to a level of principles as opposed to mere pragmatics. I find that deeply dangerous. I find it just contravenes kind of the core of what the First Amendment is supposed to do. And so, I'm just playing the joints. I appreciate, democratic process. Obviously, that's the cornerstone of how our government functions. But there are side rails, and the side rails are impermissible. Constitutionally prohibited discrimination is happening, and at that point, it just shouldn't matter.
Great. All right. Now let's start to look to the future. And let me ask this question based on my personal history. When I was coming up doing policy stuff, like my first jobs in the late 1990s, early 2000s, working in the education circles, the one thing that was just assumed is that government education programs just couldn't intermingle with these faith-based institutions, especially when it came to funding. And so whether we were talking about Title I dollars or Title II dollars, which are largely for professional development, certainly charter schools, that there was this wall that if you're going to be faith-based, you can't get the grant, you can't do religious things. It's just what we expected. So if you had told the 25-year-old me where we are right now, I wouldn't have believed it, but I also would have had all of these questions. And that's what I want to get to right now, which is if there is no status use distinction, and if it's the case that the general policy that the court is laying down is if the government is providing a benefit widely available, it can't exclude religious groups, individuals from participating. And that means it's not just that you're religious in your identity, it's that you're doing religious things. What does that mean for, Nicole, maybe you can start with charter school laws, and then maybe Michael, if you want to take on the question of professional development dollars. And we're literally talking about billions and billions of dollars every year, but also early childhood pre-K programs and anything else. Like, where do we stand now if after these three major cases, Espinoza, Trinity, and Carson? So Nicole, do you want to go first?
Sure, I'm happy to. I would say I think that the answer to the question that you're asking, Michael, is easier than the charter school question because it involves a direct application of the holding of Carson, Espinoza, and Trinity Lutheran to other kinds of programs. But so the charter school question is it's something I'd like to talk about. I think a lot about. There is the Establishment Clause clearly prohibits the government from actually operating religious schools. No one's actually questioning that. If charter schools are called public schools. So if charter schools are the equivalent of government schools, they must be secular. But the trick, of course, is they're not. They're privately operated and they are not subject to government control. They're subject to varying degrees of government control depending on the state, but not to the level of a district public school. So they look a lot like private schools in many ways. They have some attributes of public schools too. Whether or not how Carson applies to charter schools, I think turns on a different doctrine. It's called the state action doctrine. It's confusing and no one really knows what it means. But it basically means private entities are not bound by the Constitution unless they're controlled by the government. So if charter schools are controlled by the government, then they're bound by the Constitution, including the Establishment Clause. And if they're not, they're private schools and they're not, and they can be religious. And in fact, not only could you allow them to be religious if you're a state, say, let's take Minnesota, that you must allow them to be religious. So the question, in some sense, like in lay person's terms, are charter schools public schools, or are they a program of private school choice? The court says you don't have to set up any particular education funding program, but if you set up a program of private school choice, then you can't discriminate against religious providers of education. And that's a really complicated question. And in fact, the state, the circuits have divided on whether charter schools are state actors or whether they're public or private schools. The Ninth Circuit has said California and Arizona charter schools are not state actors. And the Fourth Circuit en banc just said that the North Carolina charter schools were. None of those cases had anything to do with religion, by the way. The Fourth Circuit case was an equal protection challenge to a requirement that girls wear skirts in a classical charter school. And the dissent, there is a very vigorous dissent, which I think is right. It says, you know, these things look like private schools. That question is the pivotal question for the charter school. Are they public, like district schools, or are they more like private schools, so they're not bound by the Constitution? And that's going to take a while to play out. And I think, interestingly, the answer might differ based on the state, because some states control charter schools more than other states. So last thing I'll say about this, if you just take Minnesota. So Minnesota has multiple charter authorizers, including private authorizers, including private religious authorizers. So this University of St. Thomas is an authorizer of charter schools. University of St. Thomas, a pervasive religious college, can create a charter school, but that charter school that is created by a private religious entity cannot be religious. That's where it stops making sense to me. That's where it starts looking like a private school and actually starts looking like religious discrimination. I don't know how the question will come out. It's a fun question to play with. I think it's a long game question.
Let me just say one word about this from the majority decision that Roberts wrote that really stood out to me along these lines is when he was answering the question that essentially the private schools that were participating in Maine's program, when he was answering the question that really they're functioning as public schools, the answer was, well, wait, you allow those private schools to maintain their own standards and tests. That's very private-like. You allow them to make decisions on teacher certifications, who they're hiring. They're very private-like in that way. The one thing that you're doing to keep them out, deciding that they're not really public, is the secular element. The same thing could be said about charter schools under most laws. They have freedom along all these other dimensions: curriculum, staffing, schedule, so forth. But they can't be faith-based. So I wonder at what point there's going to be a plaintiff who says, "Listen, just based on what you're saying in Trinity Lutheran and Carson and so forth, it really looks like charter schools are functioning as private schools, apart from this one area where the state just won't allow them to be faith-based. Is that fair?" I don't know how that's going to work out, but I could imagine that paragraph from Carson is going to come up a lot.
I think there will be lawsuits. There may be some states that try just amend their laws. I mean, the charter school community doesn't want to not be private. So, I mean, it's complicated politically as well as it is legally. There will be lawsuits about this, and it's and I don't know. Like I said, it's hard to say for sure how it ultimately comes out. I think the question, though, isn't actually a question about religion. It's a different question. It's about sort of the existential nature of what a charter school is, and that's something that charter schools have always struggled with. They're a strange contraption that we invented in the 1990s to avoid enacting voucher laws. Really, that was the inception of them. A kinder, gentler, secular private school choice, called a public school choice. So I think it's sort of the question really runs deep into the kind of debates about how much choice and what kinds of choice we should have in the United States.
Agreed. All right, Michael, all these other kinds of programs, if we expand this beyond just education programs, whether it's teacher professional development or something else, but anything when you have a religious group who wants to get, say, a state grant to do some sort of public service, addiction recovery, helping some kind of social service, historical trust, which you've mentioned before. Are all of these groups, are they now eligible to get state funding, even though they are clearly faith-based?
I think the answer is, in principle, yes. Here's kind of how it has to work. And government isn't always good at this. But government ought to expressly, but has to articulate some sort of government interest, something they're trying to accomplish with a funding program. And what they're trying to accomplish needs to be secular, by which I mean it can't be that they're funding religion qua religion. They can't say, okay, we're creating a government funding program where what we're going to do is we're going to provide money for pastors. Like, that's not an interest. That would violate the Establishment Clause. But what they can do is they can say, we want to save the environment. We want to preserve history. We want to get teachers trained. All these kinds of programs that government announces and implements when it comes to funding. There's an interest, there's a core interest, a secular interest. And then once you have something like that, it needs to be applied neutrally to all institutions that accomplish the secular government objective. So long as you're talking about an institution, whether it's religious or not religious, that can successfully deal with, issues of addiction, or can, if given the funding, can actually preserve our history, or if given the funding, can do a whole host of, secular objectives that the government has, then they're eligible. Sometimes people say, well, what's left of separation of church and state? And the answer is the interest isn't to promote or support religion. The point is all these religious institutions accomplish the government's objective in the same way as non-religious institutions do. This is going to raise a lot of questions down the road, of course, of like, to what extent can, government will likely try to gerrymander their interest in order to accomplish different kinds of objectives. And I suspect that will be the next round of litigation that we'll see. But everything has to start from that touchstone. And so long as religious institutions are accomplishing the government's objective, they qualify for the program, that is, then they have to be given funding. To deny them otherwise would be to violate the First Amendment.
Right. Okay, so let's start to take some questions from the people watching. And the first one actually gets us to think about the future of the court. What are the cases that are in the pipeline that we know about that have been taken up for the next term? Or, Nicole, you mentioned circuit splits on some issues. What is in the pipeline in this area, whether it's about education specifically or generally, this question of the tension between the Establishment Clause and free expression? What else does the court have to decide before we get more clarity on this? And what's on the horizon?
Right. So I think there are two. Well, let's just talk about, there's a couple of big buckets of questions that are not answered by Carson that the court, that are related. I don't know about any particular cases in the pipeline, but the first goes to another question that I see someone's asked, which is about the conditions upon which the state can condition participation in a private school choice program. Now, the court in Carson, it was in a sense a condition. I mean, the condition of participating in tuition to the tuitioning program was secularization, and the court says you can't. That's unconstitutional. But what about anti-discrimination provisions, for example? That's the big one. So the first thing Maine did after Carson is said, in order to participate in the tuitioning program, you have to comply with Maine human rights law, which prohibits discrimination based on LGBTQ status, including in hiring and admissions of students. Some schools, including, interestingly, the one that the little girl who was the plaintiff in Carson, who's not little anymore, she's graduated, wanted to attend, said, well, we're not going to participate then. That question, I think, remains unanswered. Perhaps the most important question, I think, from a free exercise perspective is the interaction between Carson conditioning and this thing the court has called the ministerial exception, which says that religious schools have the right to pick their ministers. Religious institutions have a right to pick their ministers free of government oversight, including religious school teachers. So can the state of Maine or any state condition participation in the school choice program on waiving the ministerial exception and saying we're going to regulate through non-discrimination rules or otherwise the hiring and firing of your teacher? So I think that conditions question. Curricular requirements would be another one. Some curricular requirements that some religious schools may not want to participate to teach sex ed or to talk about sexual orientation, gender identity. Those are big questions. I think that's sort of the first really big question. And then the second, which is another whole discussion, is what about rules that burden religion but are neutral? So, everybody has to do this. So it's not discriminatory. It's just you have to do it. And in order to do it, it would be requiring you to do something that your religion told you shouldn't do. That court has kind of, in a case a couple years ago called Fulton versus the City of Philadelphia, they kind of we thought they were going to take up that question. They sort of punted, decided to put shit down the road. They have not yet taken another case that's about whether Smith should be overturned. And so I think that's the other really big, unanswered question in this area.
Thank you, Michael.
Yeah, as usual, I agree with just about everything Nicole just said. Maybe I'll make some predictions while I'm at it. So I think, one, I don't think the court is likely. Well, I probably shouldn't make a prediction like this, but what the hell? I don't think the court is likely to take up a free exercise case that really tests the underlying theory under which the religious liberty protections under the First Amendment currently operate. As Nicole mentioned, a lot of people thought they were going to do that a couple of years ago, and once they punted, at least to me, it signals maybe this isn't something that they want to shake the foundations of right now. And if that's true, so what you likely see is a universe in which there are some kinds of conditions that you might put on government funding that I would say violate the First Amendment, violate the Constitution. If they're not neutral, if they don't abide by those terms, or they force an institution to forego an existing constitutional right, like the ministerial exception, I suspect courts will find those to be unconstitutional. I can't force somebody, I can't regulate you in a way that violates the First Amendment. And I think prevailing doctrine is I also can't condition funding in a way that violates the First Amendment. So if it's somehow gerrymandered, it targets religion, the condition in some way, I think that's going to be a problem. Or if it says, I know you can normally hire ministers in a particular way, you need to give that up to get funding, I suspect that also will be found unconstitutional under the unconstitutional conditions doctrine. By contrast, instances where you could the First Amendment would allow you to regulate the school directly in a particular way, you presumably can also condition funding in the same way. And that gets to like cases where if there are conditions put on religious institutions or schools where you're not dealing with ministerial employees, you're just dealing with somebody who has nothing to do, and whatever the boundaries of that are, that's a little bit, there's some good debates on that one, but employees that are clearly not ministerial in any way at all. They don't touch religion or the mission or anything of the school. I suspect that an across the board rule regarding funding and adherence to anti-discrimination law is likely to be held constitutional. Not for ministerial employees, but I suspect for other sorts of employees. And also if you're dealing with just generally anti-discrimination laws for schools as a condition of funding, so long as it's applied across the board, I think you're going to be good to go. I think it's going to be constitutional. The question will be is if you have conditions on funding that include anti-discrimination laws, but they're not across the board, that there are some exceptions that exist. Yes, we have anti-discrimination laws to get this funding, except if your name is Tim or kind of it's Tuesday or something like that. Anti-discrimination laws often have smaller institutions, ways in which that there are exceptions. And the Supreme Court's made quite a lot of these rules about exceptions. If you start providing exceptions for non-religious reasons, you also have to allow them for religious reasons. If states are going to go down this path and adopt anti-discrimination rules that are a condition of getting government funding, especially in the school context, and they want those rules to be found constitutional, they're going to have to be, I believe, very careful to make sure that they apply across the board and they don't start providing exceptions to others.
Yeah, I'll just give one example that I think, you think about how easily the neutrality thing falls apart. Let's say a state says that you must randomly select all participants except for siblings. That's very common, right? So you want to participate in the voucher plan, you have to randomly select if you have more demand than there is supply, but you can let the siblings of your current students in. I could see a court saying, well, that exception is, it suggests that this isn't neutral and generally applicable. And so therefore we will take a closer look at the restrictions.
Good. We got a question that I think is going to be of interest, especially old school education reformers, but policymakers who believe in choice, but also believe in what used to be called the standards and accountability movement, which was there was this view that one of the ways, or the primary way to make schools get better performance, was to clearly articulate what the standards are, what students were supposed to learn, develop curriculum around that, and then test all students. And that's different than necessarily the school choice way of thinking about it, which is don't worry so much about these input measures, don't worry so much about the regulations, just free everybody up and then the market will make things better. I'm oversimplifying, but there are two different ways of thinking about how to make schools better. Charters were designed to try to do both of those things, give families choice, allow some differentiation, but make sure that charters were still public school in the sense that they had to follow standards and have tests and report their outcomes. What does this new line of cases mean for that? So if a state wants to have a choice program, but also wants to make sure that the public money that is going to these schools of choice, including religious schools, that they are adhering to, parallel with, or at least shooting at the same kind of standards and student outcomes that the state wants. Is there a collision happening? Are these things consonant? Or once you decide that you're going to include private schools, you got to give up your hope that they're all going to be part of a single accountability system related to student outcomes?
This is a big issue right now in New York. There's kind of new regulations coming down the pike that I know a lot of certain segment of the Orthodox Jewish population in New York is deeply concerned about. Kind of these are the substantial equivalency rules that come out of New York State education law. And there are a lot of religious Jewish schools that are particularly concerned about some of the requirements. You know, to my mind, if you're talking from the perspective of Carson v. Makin and a principle of neutrality, you know, so long as, at least on First Amendment grounds, so long as the rules are neutral, there's a government interest clearly articulated. We have an interest in education that meets these particular standards. There's no reason to think, at least to my mind, that there would be a First Amendment problem. You know, this is when you start getting into questions about 14th Amendment, the right of parents to control the upbringing of their children, and whether or not there's a substantive due process claim here, or something along those lines. Substantive due process, as we know, is certainly in the news of late. And so, you know, that kind of takes us to a slightly different issue than the one we're discussing directly on the heels of Carson, whether or not there are some limitations as to the kinds of standards that a state can require. One would think that in the main, which I guess is a funny turn of phrase given our current conversation, in the main, a state would certainly be within its rights to require things like, you know, language arts, English literature, math, science, history, kind of the thing, you know, things that are the basics. You know, as it starts to veer further and further afield, you can imagine the beginnings of a 14th Amendment claim. You know, the state's gone beyond what it really needs. All of a sudden, they're imposing things that maybe there's no good reason, and maybe at that point, the 14th Amendment rights start to kick in. So, you know, maybe there are some questions on the edges as to, you know, the limitations that that states may have in terms of implementing standards and having that sort of accountability. But I think those are edge questions. I would like to think at the core of it, it's completely consonant with Carson to require neutral standards applied across the board to both public and private schools, and to provide funding on that basis.
I think I agree. I mean, I agree. I would say, like, not all things can be resolved in the courts. I mean, the private school choice movement has actually succeeded remarkably, not real in skirting a lot of standard accountability requirements now imposed on all charter of district schools. Indiana, I think, is the only state that requires all schools, every kid in the school that gets a voucher, to take the state test. I don't think that requirement violates the First Amendment. I think making somebody take a test may be different than making them teach something. I mean, I can imagine a world in which there's a sort of a religious liberty forced speech claim if the requirement wasn't teach whatever you want, but take the test, which is basically the regime that this sort of fits into most like regulation of private schools that requires some testing. Or you must teach something that actually violates your religious principles. So you must say that, you know, certain, you know, that creationism is wrong. You must say that. I think that would be, I mean, most of these, there have been challenges to curricular requirements and testing requirements even before the school choice movement, and they're almost universally unsuccessful. So those are, like Michael says, those are edge issues. I can imagine them coming up, but I don't think in the main, most accountability requirements would violate the free exercise clause. If schools don't like them, then they can fight politically not to have them imposed on them.
Great. Okay. Well, we only have a couple minutes left. So what I want to do is give each of you the chance to say whatever you think hasn't been said yet, but needs to, but also give you the opportunity to refer, if you think it's valuable, to the other major religious liberty case that came down in this term, Kennedy versus Bremerton School District. This is the one with the football coach praying at midfield after games. Does that case tell us anything in conjunction with Carson about this court's direction on religious liberty and education issues, or are these two just under different doctrines and we shouldn't think about them together at all? So you can address that and or have a final statement, or just ignore the Kennedy-Bremerton thing. But given that it got so much attention, I thought I would give you the chance to reference it if you would like. Michael, you want to go first?
Sure. So I think in some ways, Kennedy v. Bremerton is consistent with Carson v. Makin in that it's this heavy focus on the Establishment Clause as at its core protecting against certain kinds of neutrality or coercion, kind of slimmed down Establishment Clause that its goal is to make sure that everyone's treated the same and nobody is forced to do anything contrary to their faith. And you can see hopefully the way in which those don't deal with things like entanglement and endorsement, constitutional tests that ask more questions about the challenges of government involvement or the challenges of perception of the government favoritism of one faith or one version of faith over the other, but, a slimmed down Establishment Clause. And I think in that way, they are consistent. I would say that while I have great comfort with a neutrality paradigm when it comes to funding. And I would even say the idea that a coach in his private capacity had the right to pray and to lose his job because he engaged in that kind of private prayer, I think is something that needs to be protected by the Free Exercise Clause. I do harbor these kind of ever so present worries that questions of coercion are a little bit harder to test than questions of neutrality. I know if everyone's getting the same amount of money, but do I know if somebody is being subtly pressured in the context of a school to engage as a student, to be engaged in, my favorite teacher's preferred form of prayer or not? Schools are kind of chaotic. My wife actually works in a school. I hear all the time, every night. Schools are chaotic. Her school is not chaotic. She's talking about other schools, of course. There I worry that as we slim down the Establishment Clause, figuring out ways to make sure that every individual is protected from coercion, even forms that are subtle and informal. I worry that a slimmed down Establishment Clause, I think it can do it, but there's going to be a lot of hard work when it comes to the facts and circumstances of cases to make sure that's something that courts uphold. So consider that kind of my view as to, these cases are consistent in an important way, but facts and circumstances, especially in the school context, are hard. And if we're going to make sure to fulfill the promise of these cases, I think there's a lot of very hard work ahead.
Great. Nicole?
So I agree completely with Michael that the Kennedy and the Carson case applied in some sense the same principle, which was this principle of neutrality. So the government must be neutral toward religion. It can't pick on people for praying, and it can't kick out schools for being religious. This was also an emphasis in the third case the court had, which was called Shirtless versus Boston, which is about flying a Christian flag and in front of Boston City Hall as part of a community flag flying program. So this neutrality principle, I think, if anything, it really cements that the Free Exercise Clause, the Free Speech Clause, and the Establishment Clause all sort of come together, tied neatly into one neutrality bundle. And the other thing about Kennedy, which I think is important, is that the court definitively jettisons the Lemon test. It says it's been gone a long time ago. It sort of seemed to have forgotten it, overturned it, but it's like, Lemon is really dead. It's not going to come shuffling out of the grave like a ghoul that scares small school children, which is what Justice Scalia once referred to it as. And it also definitively got rid of this pernicious test called the endorsement test, which said, well, to determine whether something's constitutional, we're going to ask whether a reasonable observer would think the government was endorsing it by permitting it. And I wrote a brief with a religious liberty clinic in Notre Dame in the Kennedy case where we just went through like a parade of horribles that the endorsement test had created in schools. Like there was a circuit split about whether it was unconstitutional to allow children to pass out candy canes with Bible verses taped to them. Literally, there were like cases where kids were told to take off the hijab at the yarmulke or wash off their ashes on Ash Wednesday because the school would be endorsing religion by allowing them to continue this religious wear. Parents being told kids can't read their Bible at recess. I mean, so, and all in the name of avoiding the establishment of religion or by appearing to endorse. I mean, it was never workable. So I think that's actually really good news. The lemon test has always been bad news, and the endorsement test has always been unworkable. So I'm pleased by that. But I think Michael's right. What's been replaced, at least in the school context, is this coercion test. And I don't think we yet know what that means. And schools, I teach education law. I like to say every classroom is a courtroom. I mean, schools are chaotic places, and teachers are made mistakes about endorsement and candy canes and whether or not you're allowed to write that God is your idol in a report. That one little girl wasn't allowed to write that God was her idol, but she was allowed to substitute Michael Jackson. So, those were mistakes, but people can make mistakes about coercion too. So I think there's a lot more work to be done to determine really the implications of Kennedy.
Thank you. Well, we have hit 2:00, and I promise to get everyone out of here by then. If nothing else, I have learned a great deal. So thank you to our two professors, Garnett and Helfand, for joining us today. And for all the viewers and all of your questions, thank you for sending those in. Sorry I couldn't get to them all. Just know that we are going to stay on top of these issues, whether in the next term, similar decisions come down, or in between we'll have more events like this, because this seems to be not only an important area of law, but it's changing in a way that I just didn't see coming 10 years ago. And it's going to affect not just lots and lots of schools and students, but lots and lots of government money in one direction or the other. So an exciting topic, and I'm happy that we get to take part in it. So thanks again to our guests for joining us, and thanks for everybody for watching, and for the Manhattan team for putting this on. Have a great rest of the week, everyone.
Thank you.
Thanks so much.